Remington Stone versus Marley Miser and Acme Construction Company. Counsel, are we ready to proceed?
Your Honor, if the court pleases, may I address two matters before we begin?
Go ahead.
May I approach?
Sure.
First, I would like to provide you with a roster of our attorney and witness sheet for today's trial.
Thank you.
And secondly, I would like to request that all witnesses for the defense, including Marley Miser, Reese Withers, and Dr. Skylar Harris, be sequestered during the plaintiff's direct examination.
Your Honor, the defense objects to this. Pretrial motions are not permitted, like that are not permitted in the mock trial rules. And anyways, I don't believe that the testimonies of these witnesses would be upset by any of the testimonies of the plaintiff's witnesses.
Well, it is customary in my court to have witnesses excluded during testimony, so we'll have the witnesses step aside
Thank you, Your Honor.
after introductions.
All right, and then Your Honor, may I approach for the
Yes, please. Thank you. And are we ready to proceed, counsel?
Yes, Your Honor.
All right, let's have the witnesses step aside. Please proceed, counsel.
Thank you. Good morning, Your Honor. I would like to introduce the plaintiff's legal team tonight. My name is Zach Kianos. Today I will conduct the direct examination of Dakota Springs, played by Katrina Strains, and will be cross-examining the defense's witness, Reese Withers. My first co-counselor is Curtis Hannon. He will conduct the direct examination of Remington Stone, played by Declan LaForest, and the cross-examination of the defense's witness, Marley Miser. My second co-counselor is Josiah Sprague, played by Jason. He will conduct the direct examination of Dr. Alexis Anderson, played by J.C. Hannon, and the cross-examination of the defense's witness, Dr. Skylar Harris. Today we are here to hold one person accountable for a horrific workplace accident that could have been prevented. Marley Miser. Our client Remington Stone is the unfortunate victim of an absolutely tragic accident that resulted from a lack of adequate safety precautions and misguided supervision. Mr. Stone showed up to work like any other day, simply trying to make a living. Like any other worker, he was given his task, and this was not by any means meant to be a dangerous task. He was to use a ladder and a claw hammer to tear down drywall. However, negligence at the hands of the defendant alone would quickly lead to disaster, resulting in a fall and electric burns sustained by Mr. Stone. With the testimony and evidence we will provide today, it will be made clear that the homeowner, Marley Miser, is at fault. Marley Miser was a critic of Remington Stone from day one, picking on him specifically and critiquing only his work. With the pressure of the homeowner constantly critiquing his work and getting the job done, this really specialized the attention onto our client. And it is clear that the defendant had a de facto role in managing the job site. We will lay out the argument and that the defendant held this supervisory role with his constant presence and participation at the construction site. Labor Law Section 241 states that parties that are liable for reasonable workplace safety equipment and operation, including contracts and their agents. We have the burden to prove that the defendant Miser was indeed an agent, and it is understandable that a homeowner would be nosy about the work completed in his or her home, but Marley clearly demonstrated involvement beyond being curious. He gave advice, he reported progress to company management, and even participated in physical work. This characterizes the defendant as an actual agent and voids the exemption of Labor Law Section 200, 240, and 241 that protects a homeowner from that liability. This exact situation has a legal precedent in the case Tonksys v. Apex Construction, a court ruled that the Labor Law Section 200 was violated due to a homeowner's exercise of supervision at a construction site. The presence of dangerous conditions at the site coupled with this participation from the homeowner and resulted in a suit that provided in favor of a worker being injured on the job. The case being discussed today arguably had a similar set of circumstances. And to further support our argument that the defendant is liable, we will discuss the factors that contributed to the accident that has forever changed the life of Mr. Remington Stone. An accident reconstruction expert, Dr. Alexis Anderson, will speak out today about a professional accident reconstruction report. He is the only expert that will speak today that interviewed both the defendant and the plaintiff as part of his investigation. Evidence supporting his report will not only fault the defendant for providing Mr. Stone with a faulty ladder, but also a failure to disclose a danger hidden in his home: live exposed electrical wiring. In close, with our argument today, we are confident that Mr. Marley Miser will be found to be a culpable and beyond reasonable doubt for Mr. Stone's accident. We ask the court to take into consideration that the defense will be aiming to chip away at the character of our client and for struggles that he has had in the past. The fact of this matter is that Remington is not that person. He is a strong-willed man who has worked through his problems. He turned his life around and has been on a positive path for quite some time. Remington was not a victim of his own failures. Instead, he was a victim of Marley Miser's negligence. Thank you, Your Honor.
Counsel.
Yes, Your Honor. Defense counsel requests that plaintiff's witnesses are sequestered until they're needed, as you've disclosed. That's typical in your court.
That'll be fine. With the exception of the plaintiff can remain.
May I proceed?
Go ahead.
May it please the court, Your Honor, fellow counsel. Your Honor, the plaintiff's side has just discussed all of the horrible things that have happened to Remington Stone. These, of course, include injuries such as third-degree burns and serious nerve damage. The defense doesn't dispute these awful injuries. It's obvious the plaintiff has suffered greatly. However, Your Honor, the defense does dispute who plaintiff's counsel is putting the blame on. But before I continue, allow me to introduce my team first. My name is Jacob Sears, and I will be directing Reese Withers, who is played by Adam Spack. My co-counsel is composed of Xander Pitts, who will be directing Marley Miser, played by Griffin Lewis, and Christina Oyer, who will be directing Dr. Skylar Harris, played by Riley Spoon. Remington Stone has brought Marley Miser to court today on the grounds that the conditions of his worksite have led to an accident. Remington claims that Mr. Miser neglected to maintain and upkeep the premises and ensure the safety of the workers doing integral parts of a home renovation. They claim that Mr. Miser provided them with a dangerous worksite. However, even though it's easy to blame the homeowner in a tragedy such as this, it was simply just that, an accident. There is no reason to bring a hapless old man like Marley Miser into a case like this. He regrets the horrible circumstances of the accident, but he shouldn't be held accountable for something that simply just wasn't his fault. Marley Miser will testify about the lead up to the accident and the circumstances surrounding it, along with his role as a homeowner on the job site. Another person present on the work site, Acme Construction Site Supervisor Reese Withers, will testify about the safety precautions and procedures that are expected to be followed on company work sites. He will also testify about equipment that should or should not be used on job sites. Finally, an expert professor in mechanical and industrial engineering, including workplace safety, Dr. Skylar Harris, will demonstrate that through her investigations, a person of Remington's size and weight would never have fallen on a properly pitched ladder, even on a wet, slippery floor. Through the testimony of Marley Miser, we will prove that Marley Miser had no part in the accident, that the plaintiff made all of the choices that led up to the accident, from using a faulty ladder to placing it on a slippery floor, and that Marley Miser, as a homeowner, had no responsibility to upkeep or prepare a job site. Through the testimony of Reese Withers, we will prove that Reese repeatedly instructed the plaintiff to use safety rules such as the 4-to-1 ladder safety rule, that the plaintiff was out very late the evening before at a company party, rendering them unfit for construction work the next day, that the ladder used by the plaintiff was not approved for Acme Construction use, and that Acme Construction and its agents are responsible for all employees and the work that they do on their job sites. And finally, through the expert testimony of Dr. Skylar Harris, we will prove that when positioned properly, the aluminum edges of a ladder would not have slipped on wet vinyl. She will further demonstrate this fact through her testimony of the reconstruction of the accident. The statutes that this case is based on, Nirvana Labor Laws 240 and 241, also demonstrate that the law is on our side. The law is clear, Your Honor. It absolves liability of those owners of one or two family dwellings who do not control the work. Your Honor, Marley Miser simply contracted out the work being done. He didn't direct or control any of it, and that, along with the fact that he's an owner of a two-family home, shows that he has no reason to be held responsible today. Additionally, Labor Law 240 states that equipment such as a ladder, which is a main player in today's case, must be placed and operated to provide for the protection of workers. Well, Your Honor, not only was the ladder that the plaintiff had his accident on not intended to be used since it was placed far away from the job site and wasn't even Acme Construction property, the responsibility for an accident like this must be placed on whomever is operating the equipment, which, in this case, was Remington Stone. Your Honor, the plaintiff has accused Marley Miser of causing them personal injury. While the defense would agree that this accident was terrible and that the injuries suffered by the plaintiff were horrific, we also have to be reasonable when assigning blame in such a tragedy. Remember, Your Honor, the plaintiff's side bears the burden of bringing forth clear, credible, and convincing evidence that the actions of Marley Miser led to an accident. However, the defense believes that no such evidence can be brought forth since no such evidence exists. Mr. Miser sympathizes with the plaintiff. Something truly awful happened that day. However, the wrong person is being sued here. Mr. Miser is just a homeowner. He has no place in a case like this. Acme Construction should be the one that's held accountable. Mr. Miser would simply like to put this mess behind him and let sleeping dogs lie. Your Honor, at the conclusion of this trial, the defense asks that you rule in favor of Marley Miser and absolve him totally of liability in this case. Thank you, Your Honor.
Counsel, are you ready to call your first witness?
Yes, Your Honor. May I call Remington Stone to the stand?
You raise your right hand. You solemnly swear to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, put your hand down. And state your name for the record.
My name is Remington Stone.
Counsel, your witness.
Greetings. Could you please state your name and address for the court?
My name is Remington Stone. I live at 32 South Percy Street, apartment 312, Gotham, Nirvana.
Could you please also tell us your current occupation?
Well, I was working for construction workers local 1212, but due to an unfortunate accident, I no longer can. It's just terrible.
When was this accident that put you out of work?
Today, I just won't forget. It was terrible. It was September 23rd, 2021.
Where did this accident occur?
It occurred at an old Victorian home owned by Marley Miser that I was working at.
Okay, Mr. Stone. Let's discuss what led to the scene of your accident. Briefly, could you describe why you applied to work for the construction workers local 1212 in August 2021?
Could you repeat the question?
Yes. Briefly, could you describe why you applied to work for construction workers local 1212 in August 2021?
Well, I needed a job and I had some experience in that field, so I figured that that would be a decent fit.
Where did you work previously?
I previously worked at the Electrical Workers Local 1000 Union as an apprentice.
What did you like about your opportunity working for the local 1000?
Objection, Your Honor. Relevancy?
I'm going to allow it.
I will repeat the question. What did you like about your opportunity working for the local 1000?
It was good work and good pay, and I didn't have to completely give up my dreams of working with a band. I made some connections with bands through that job. Things were looking up at that point.
What became the issue for you that led to your dismissal from Electrical Workers 1000?
Well, eventually, things had changed, and I started going to bars to make connections, and I had developed a drinking problem.
What treatment did you seek for your drinking problem?
I joined a 12-step plan in, I believe, 2019, and I completed it. However, after completing it, I went through a tough relapse, and then I joined and completed another 12-step plan in 2020.
How long have you been sober since completing your latest 12-step program?
I've been sober since, I believe, March 2020.
Let's move on to your employment at the local 1212. So when did you start working for construction workers local 1212?
That would be August 2021.
We already discussed that you were first assigned to work at the defendant's home project. How long did you expect to be working at the Miser project?
The schedule said it would be complete in about 3 months.
Could you briefly describe your first days working at the defendant's home?
Objection, Your Honor, relevancy.
Counsel?
I believe this is very relevant to the case, as this is the place where he sustained his injuries.
I don't see how his first day at work could affect the outcome of this case at all.
All right, I'm going to allow the question.
Thank you.
Go ahead.
I will repeat. Could you briefly describe your first days working at the defendant's home?
Marley was just keeping an eye over us the whole time. It was pretty rough. He kept butting in and giving advice to anyone he wanted to. We were all just under his supervision at that time.
Who was frequently left to keep an eye on the job as you and others worked on the defendant's home?
Marley Miser was because he was around more than the actual Acme supervisor, Reese Withers.
How frequently did you interact with Reese?
Reese would give us our assignment and be gone most work days, but Marley was there the whole time.
What is your knowledge of Marley's experience in construction?
We were told he worked as a building inspector and worked in construction for a majority of his life. I didn't dare ignore what he was saying in case he reported me to Reese or someone else.
Now that we have an idea of the experience working at the Miser residence, let's discuss the day of your accident. Could you briefly describe what happened the morning of September 23rd, 2021, as you arrived at the job site?
It was a work day like any other. The only problem was that the ladder I needed was in use.
So what did you do when you were unable to access the ladder you needed to perform your work with?
I found another ladder at the residence and I asked Marley if I could use it. He seemed annoyed but did not tell me no.
What did you choose to use, or why did you choose to use the ladder rather than wait for the ladder that was provided to you at the Miser project?
Because we had a job to be done and we needed another ladder, and we had to stay on schedule.
How did using the ladder work out?
Apparently the floor was wet and I hadn't noticed, so I slipped off, so the ladder fell out from under me, and unfortunately it hit exposed electrical wires and burned my hands.
Why do you hold Marley Miser responsible for your accident?
I believe, he could have said just about anything, like, don't use that ladder. There is water on the floor.
Objection, Your Honor. Witness is speculating.
Counsel?
I believe the witness is just giving examples of what Marley should have said to him.
I'm going to sustain the objection.
All right.
Thank you, Your Honor.
What have you lost as a result of this accident?
Nothing less than everything. I've lost my dream job and any opportunity for it.
May I approach, Your Honor?
Sure.
May I have this marked as plaintiff's proposed exhibit 1?
All right, it's now marked in said exhibit. Plaintiff's home.
Plaintiff's proposed exhibit. The record of this lecture has shown the witness plaintiff's proposed exhibit. Do you recognize this medical incident report from the Gotham General Hospital?
Yes, it's my medical report from the accident.
How do you recognize this report as your injury report?
It has all my personal information, my name, my address, my number, just everything, and it has the same injuries I sustained.
Does this report appear to be in the same condition it was when it was created and provided to you by attending physician Dr. Hauser?
Yes, it does.
Your Honor, I now move for the admission of Exhibit 1 into evidence.
Counsel?
I object based on hearsay. There's no custodian of the records, nor is the attending physician here to testify that this is a proper representation of their injuries.
Unfortunately, due to mock trial, we cannot have more than 3 people or 3 witnesses in, so we were unable to bring Dr. Hauser in today.
All right. I'm going to allow the exhibit since it is his own medical record and he's identified it as his own.
Thank you, Your Honor.
Where do you want me to put it, Your Honor?
Well, at this point, it's now in evidence. I'll take it up here. If you need it again.
According to the report, you sustained third-degree burns and symptoms of electrical shock. Could you briefly tell us about these injuries?
Well, I knew I'd been shocked just immediately. I'd been knocked flat. But the worst part was the pain from the burns.
This report did key in on you being disoriented. I noticed here that you were not tested for blood alcohol content. Could you tell us a little bit about that?
I have been sober for years, and I do not believe that it is necessary to test that, as I've had none, and I believe my doctor must have felt the same way.
This whole thing must have been a whirlwind for you. You've given us plenty to discuss related to your situation. How else have you tried to gather facts related to your accident?
I hired a professional to recreate what actually happened that day.
To wrap up, let's touch on a few important items. What were your observations of workplace safety from the Miser worksite?
A bunch of corners were cut to make the deadline, Marley's deadline.
Who did you observe overseeing the Miser worksite during the majority of your time working there?
Marley Miser.
What observations can you share with us about the defendant's physical participation with this project?
Could you repeat the question?
What observations can you share with us about the defendant's physical participation with this project?
Well, he was there supervising. He helped install flooring. He was definitely involved in with the project in some physical way.
Why would you consider Marley Miser to be a supervisor or an agent associated with this project?
Objection, Your Honor, calls for a legal conclusion.
I'm just asking his observations on how Marley Miser is involved in the workplace.
I'm going to, if you want to rephrase your question, I'm going to
All right.
sustain the objection.
I will withdraw my question from the records. Lastly, what are you seeking from the defendant, Marley Miser?
I am seeking Marley Miser to be held responsible for what happened at his home. I believe it is his fault, and there are damages to be repaid, especially my injuries.
No further questions, Your Honor.
Thank you. Counsel?
May I cross the witness, Your Honor?
What's that?
May I cross-examine the witness? Good afternoon, Mr. Stone. Do you own a journeyman's license?
Could you repeat that?
Do you own a journeyman's
I
license?
object, Your Honor. How is this relevant to the case?
Counsel?
Your Honor, this is cross-examination, and I'm moving to impeach the witness. Just give me a few questions, and I'll tie it in.
All right. Go ahead.
Thank you.
I do not believe I do.
And were you enrolled in a 5-year program to get this license?
I believe I was.
Well, why didn't you complete it?
I object, Your Honor. The lawyer is using previous events to diminish my character's status as a worker.
Your Honor, this is cross. I'm moving to impeach the witness.
I'm going to allow it.
Thank you. Would you like the question repeated?
I would.
Well, why didn't you complete this program to get your journeyman's license?
I do not recall.
Didn't you cause an accident at your place of
I
employment?
object, Your Honor. The lawyer is diminishing my witness by using prior evidence.
I need to hear the whole question first, counsel.
All right.
Did you cause an accident at your place of
I
employment?
object, Your Honor. This question has already been asked and answered by me.
Your Honor, I was repeating the question.
Counsel, I have not heard the full question.
Mr. Stone, did you cause an accident at your place of employment previous to Miser's home?
That would be correct.
And did you choose to come into work that day?
I object, Your Honor. How is this relevant whatsoever to this case?
Counsel?
I'm trying to establish a pattern of behavior with workplace safety, Mr. Stone.
I'll sustain the objection on that
Okay,
question. Go
I'll
to the
move on,
next
thank
question.
you. Did you cause harm to another coworker named Earl?
I object, Your Honor. This question has already been asked and answered by me.
I didn't ask it.
I'm going to allow it on the cross.
Would you like the question repeated, Mr. Stone?
I would.
Did you cause harm to a coworker of yours named Earl?
I object, Your Honor. This is outside the scope of the direct examination.
Your Honor, counsel just stated that he had asked this question during his direct examination.
Counsel, how is this relevant to this?
I'm trying to establish a pattern of behavior with his workplace safety and the accidents that he's caused.
I'll allow it.
Did you cause harm to a coworker of yours named Earl at this accident?
I do recall something of the sort happening.
And was this because you were hungover that morning?
I object, Your Honor. How is this relevant to the case whatsoever?
Counsel?
Your Honor, I've been trying to impeach this witness on the same account for many questions now, and I believe that this is the same objection, same answer. I'm moving to impeach this witness based on patterns of behavior.
I'll allow it.
Was this because you were hungover that morning?
Possibly it could have been.
Okay. And again, you chose to come into work on that morning?
Well, yeah, I have a job.
So your actions caused those injuries?
I object, Your Honor, on the grounds of character evidence.
Counsel?
Still moving to impeach the witness. This is just showing pattern of behavior. It's not about his character at all.
I'll allow the question.
So your actions caused those injuries to your coworker?
It could be seen that way by some.
Okay, thank you. So what day were you injured concerning this case?
That'd be September 23rd, 2021.
And when at work, you chose to use a ladder without rubberized footings, correct?
Well, yeah, I had a job to be done.
And you chose this ladder completely of your own accord?
With no,
But you chose this ladder of your own accord. You chose it. No one forced you to choose it.
yeah, with no denial from our.
Okay, thank you. And you didn't notice that this ladder had a lack of footings on it, did you?
I object, Your Honor. This question has already been asked and answered by me.
Your Honor, I haven't asked this question.
I believe I have.
I will allow the question.
And you didn't notice that this ladder had a lack of rubberized footings, correct?
I do not believe so.
And did you pitch that ladder on a wet spot on the vinyl flooring?
Without noticing the wet spot.
Your Honor, may I approach?
Yes.
Oh, thank you. May I have this marked for identification as defense exhibit A?
No, I'd mark for identification defense A.
The record reflects the insurance opposing counsel has been marked as defense exhibit A. Yeah, approach the witness.
Go ahead.
I'd like you to read paragraph 16, 780%. Honor, may I retrieve Defense Exhibit A?
Has the witness completed reading the paragraph you asked him to
I
read?
have completed it.
Okay, go ahead.
Thank you. So, I'm gonna ask you, did you notice that the vinyl flooring was wet before you put that ladder there?
I believe in there it said it was Miser's responsibility to. I do not believe it
Well,
said.
I'm not asking whose responsibility it was. I'm asking whether you noticed that the ground was wet.
I do not believe that said I did, unless I misread it.
I'll move on. You chose to put the ladder on the ground without the rubberized footings, knowing that there was risk in that, correct?
Yes, because that's where I had to work.
Okay, thank you. And you did this in a sound state of mind?
Barely, yeah.
Did Marley Miser control any of your choices on that day?
No, but he didn't discourage it.
Okay, thank you. And what were you doing the night before your accident?
I believe I was at a
I object, Your Honor. This is outside the scope of the direct examination.
Counsel?
I'm moving to impeach the witness again, Your Honor. If you could give me a little bit of leeway, I'll tie it in.
Go ahead.
Thank you. So what were you doing the night before your accident?
I was at a retirement party for, I believe, Frank.
Okay. And were you out late into the night?
I object, Your Honor. How is this relevant to his injuries sustained whatsoever?
Counsel?
I'm trying to establish his state on the morning that he was injured. So I'm just giving a few questions. I'll tie it in.
I'll allow a little bit more, but
So were you out late into the night that night?
Your Honor, I do believe that the time is up.
has time passed? Okay.
Given the amount of objections, I'd ask that I get a little bit of extra time.
But we're going to keep to the time limits here.
Okay, thank you.
Thank you.
No more questions at this time, Your Honor.
Thank you. Any redirect, counsel?
Yes, Your Honor.
Please proceed.
How long have you been sober?
I believe since March 2020.
No further questions, Your Honor.
Thank you. Any recross?
No recross, Your Honor.
Thank you. Witness may step down. Counsel, do you have another witness?
Yes, Your Honor. The plaintiff would like to call Dakota Springs to the stand.
Thank you. You can raise your right hand. You swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
I do.
All right, you may have a seat. Please state your name for the record.
My name is Dakota Springs.
Okay, counsel, your witness.
Good morning, Ms. Springs. How are you today?
Pretty good.
Awesome. Could you please state your name and address for the court?
My name is Dakota Springs, and I reside at 245 Hill Street, Gotham, Nirvana.
What is your current occupation?
I am a union rep for the local construction workers 1212.
And how do you know the plaintiff, Remington Stone?
I am familiar with his family, and we grew up in the same neighborhood. I've known him all his life, and they're great people.
What professional affiliation does Remington have with you currently?
He is a construction worker at the local 1212, which I represent.
What can you tell us about Remington's experience as a laborer?
He previously worked at a different labor union, but he came to me in August of 2021 looking for a new opportunity, and I was happy to interview him.
What knowledge did you have concerning Remington's struggles with alcoholism during the interview process?
I talked with him and his parents about it during the interview process, and he clearly had his struggles, but he got some help, and I'm glad that he got his life together.
Knowing that Remington had these struggles, why did you choose him to work for the local 1212 rather than the other candidates that applied?
Well, primarily, I saw his background as a valuable asset. My familiarity with him was also comforting as well, but it was a hire that anyone else would make.
What qualifies you to choose and hire candidates into the local 1212?
I have been working for almost all 55 years of my life, and I've seen my fair share of applicants and can tell who can get the job done.
Where was Remington assigned to work in August of 2021?
He was assigned to work at the Miser Project.
And who is Remington to report to at the Miser Project?
He was supposed to report to the site supervisor of Acme Construction Company, which was Reese Withers.
What relationship does your union have with Acme Construction?
We pair with Home Renovator LLC, and they contacted us needing some new workers for their project.
And how do you know Reese Withers?
We are in construction together, and I know that he gets busy and isn't always on the job site, so it's no surprise that he asked Marley to watch over the workplace.
What can you tell us about any complaints that were made about Remington Stone while working at the Miser Project?
If there were any complaints, they would usually come to the union leader, but there were no complaints.
And what can you tell us about Remington's accident on September 23rd of 2021?
Well, I was not there, but I know that it's just terrible that this happened to him, and he was just a young man trying to get his career started.
When was the last time that you spoke with Remington prior to this accident?
I spoke with him at a retirement party the night before his accident.
And what did you observe of Mr. Stone during this retirement party?
He was at the bar just talking with some friends, and as a friend I asked him if he was drinking. He assured me he wasn't, and I'm very happy about that, and he was only drinking Diet Colas.
As a union representative, what do you consider an important responsibility you have to your local 1212 membership, including Mr. Stone?
It is my responsibility to ensure that my fellow brothers and sisters have a safe and responsible workplace. Nothing matters more to me.
And given your vast experience in the construction business, what is considered to be adequate and safe supervision at a construction site that really ensures the safety of its workers?
A well-trained site supervisor that's there on the job site at all times. I see too many times where homeowners
Objection, Your Honor. This question asks for an opinion by someone who's not an expert.
Counsel?
Your Honor, Dakota Springs has had a vast experience in construction, and a simple question like this, could really be answered by anyone in this field.
I'm going to sustain the objection.
Thank you, Your Honor.
Strike the answer.
No further questions, Your Honor.
Counsel, any cross?
Yes, Your Honor. Good morning, Mrs. Springs. How are you?
Pretty good.
Is it true that you've known the plaintiff since he was born?
Yes, that's true.
Is it true that you've known the plaintiff's family since high school?
Yes.
Is it true that you were at their wedding party?
Objection, may I ask, why is this relevant to our case today?
Your Honor, I'm just trying to establish that she has a connection with Remington Stone and the family, so it could show some bias.
All right, I'm going to allow the question. Go ahead.
Can you repeat the question?
Of course. Is it true that you were at the Remington Stone's parents' wedding?
Yes, that's true.
And is it true that this bonded you for life?
Yeah.
Is it true that you consider yourself a guide parent of Remington?
Yes.
And you believe family always comes first, correct?
Objection
Anyone
once
would
more,
say
Your Honor.
that.
How is this relevant to our case?
Your Honor, again, I am just trying to establish that they have a connection which could lead to bias.
I will allow it. Go ahead.
Would you like me to repeat?
Yes, please.
And you always believe family comes first, correct?
Yes.
Is it true that you've worked in construction your whole entire life?
Yes, that's true.
And is it true that it's not what you know, but who you know that will get you ahead in this world?
Sometimes that's helpful.
Who asked you to give Remington a job?
His parents came to me, but he was also enthused.
Now, you were elected union steward, correct?
Yes, I was.
And the people who work for you like and respect you, yes?
Yes, they do.
And is this because you take care of your friends no matter what?
Anyone would.
And this involves when they come into work just a little late, correct?
I mean, I guess.
And you will take care of your friends when they accidentally misplace tools.
Yeah, they're human.
Exactly. And when they just accidentally take a little too long on lunch breaks,
What'd you say?
and when they just take a little bit too long on their lunch breaks.
I mean, yeah.
Your Honor, I feel as if the opposing counsel is being a little argumentative in these questions. I'm not seeing how it's really relevant or like, where are we going with lunch breaks?
Counsel argumentative?
Your Honor, I'm just trying to establish a pattern, and in the affidavit, Mrs. Springs did confirm that what I'm asking is true.
I'll allow it.
Would you like me to repeat?
Sure.
And this includes when they just come into work just a little late, correct?
Yes.
Turning your attention to September 22nd in 2021, you attended the big retirement party, correct?
Yes, I did.
And can you tell the court what time you left around?
I left around 9 p.m.
And at this party, you spoke with Remington, correct?
Yes, I did.
And this was at the bar, correct?
Yeah, he was talking with some friends.
And you admit that you may have warned him about alcoholic drinks.
Yeah, just a friendly.
But you know Remington didn't drink anything while you were there.
Right, he didn't.
And to the best of your knowledge, when did Remington leave?
I don't know.
Do you know if this was after you?
Well, he was still there when I left.
So you don't know if Remington drank after you left.
No, but I know in my heart that he's a changed man.
Is it true that you were not on site September 23rd, correct?
Yes, that's true.
So you don't know the state that Remington was in, correct?
I don't.
And is it true that you do feel sorry for Remington? Horrible thing, right?
I mean, anyone would.
Is it true that you feel like you failed Remington's parents because of this accident?
I would feel that way about anyone else's parents.
And is it true that you will do whatever it takes to help Remington get the relief he deserves?
Yes.
No further questions, Your Honor.
Any redirect?
Yes, Your Honor.
Good job.
You could say that Remington Stone is a changed man, right?
Yes, he is.
And that he's been sober for years now?
Yes, and I'm very proud of him.
No further questions, Your Honor.
Any redirect, or recross, excuse me.
Yes, Your Honor. Just a moment. Miss Springs, can changed men change again?
That's debatable.
No further questions, Your Honor.
All right, that the witness can step down.
Excuse me, would you like me to sit there in the hallway?
You've finished your testimony. Anybody planning on any rebuttal testimony here today?
The defense has no issue with her.
You may sit.
Okay, thank you.
Counsel, any further witnesses?
Yes, the plaintiff calls Alexis Anderson to the stand.
Would you raise your right hand, please? You swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
All right, may I have a seat? Please state your name for the record.
My name is Dr. Alexis Anderson.
Thank you. Your witness.
Good morning, Dr. Anderson. Could you please state your address for the court?
I reside at 3301 Commercial Avenue, DePue, Nirvana.
Could you please tell us your association with the plaintiff, Remington Stone?
Remington's legal team hired me to investigate the accident.
What do you do for a living?
I am an industrial engineer.
What educational background do you have in this career field?
I got my degree in industrial engineering at Northeastern University.
What specifically did you study while attending Northeastern University?
I studied a number of things: biomechanics, robotics, data analytics, operations, and many more.
What did you earn as a result of your studies?
I earned a PhD in industrial engineering.
What was the subject of your doctorate dissertation?
Workplace safety.
After earning your doctorate in industrial engineering, where did you work?
I started working at Taylor & Associates in 1998, where I worked my way up to vice president and senior investigator. By 2012, I am still with that firm.
How many workplace investigations have you performed during your time at Taylor & Associates?
I've performed over 500 accident investigations.
What other experiences have you had related to workplace accidents while working at Taylor and Associates?
I've written a number of articles and books for premier publications on workplace safety.
Have you given any testimony on accident suits?
Yes, I've given testimony in many cases.
How many cases have you given testimony to?
I've given testimony in 500 cases in both state and federal courts.
Your Honor, I ask that Dr. Anderson be qualified as an expert in the field of industrial workplace safety and accident investigation.
Counsel?
Your Honor, I'd like to voir dire the witness, if I could. Dr. Anderson, isn't it true that you've no experience on a construction site or working construction?
That is true, but I investigated
Isn't
a
it
lot
true
of
that your
accidents.
chapter, How to Analyze and Diagnose Workplace Accidents, was never peer-reviewed?
I am not sure,
And this chapter did not concern construction, did it?
but I've written many other articles on construction.
Your Honor, the defense objects to this witness being an expert. I don't feel like the proper foundation has been laid to their experience with these types of accidents. While I feel like this witness could testify in a broader a set of workplace accidents, this one specifically concerns construction, which can be very different than other kinds of workplace accidents.
Thank you. Counsel?
Alexis Anderson has spent a long time investigating all sorts of workplace accidents. I will give the opposing counsel that. But in that large umbrella, I am sure that of 500 cases that they have spoken on, I am certain that at least a few of them were on construction.
I'm going to allow the witness to be qualified as an expert at this time.
Thank you, Your Honor. Dr. Anderson, let's take a brief moment to discuss the investigation report that you have provided on behalf of Mr. Stone. May I approach, Your Honor?
Yes, you may.
May I have this marked as plaintiff's proposed exhibit 2?
Now mark plaintiff's exhibit number 2.
Let the record reflect that I am showing opposing counsel plaintiff's proposed exhibit 2. Let the record reflect that I am showing the witness plaintiff's proposed exhibit 2. Do you recognize this accident investigation report?
Yes, this is the report I filled out for Remington Stone.
How do you recognize this as your investigation report?
The report includes Remington Stone's name as the injured person and my signature.
How else do you recognize this report?
This report lists Remington's accident and all about it.
Does this report appear to be in the same condition as when you wrote it?
Yes, it does.
Your Honor, I now move for the admission of plaintiff's proposed exhibit 2 into evidence.
Counsel?
Defense counsel has no objections at this time.
All right. We'll accept it into evidence.
Your Honor, may I approach?
Go ahead.
Briefly, can you tell us about how you conducted your investigation?
I interviewed key witnesses including Remington Stone, Marley Miser, and Dakota Springs. I also visited the Miser residence to investigate the accident.
Why didn't you interview the site supervisor, Reese Withers?
I felt that Marley Miser was responsible for Remington's accident.
Objection, Your Honor. This answer calls for a legal conclusion. I'd like to be stricken from the record.
Counsel?
Alexis Anderson is an expert witness. It is their job to draw conclusions.
Thank you. I'm going to allow the question.
Would you like me to repeat the question?
Yes.
Why didn't you interview the site supervisor, Reese Withers?
I felt as though Marley Miser was responsible for this accident, and Remington made notice that Mr. Miser was primarily on the site giving orders.
How did you attempt to recreate the accident Mr. Stone suffered?
Due to the fact that Remington fell off the ladder and suffered electrical burns, I felt a recreation would not be safe for someone to assist me with.
What did you conclude from your investigation?
I concluded that the ladder provided to Remington was the reason for his accident.
Let us talk about the ladder, which was a key component of your investigation. Briefly, could you tell us about how the ladder played a role in Mr. Stone's accident?
The ladder was missing rubber footing, which helps stabilize the ladder for workers when they use it, which caused the ladder to slip and fall.
During your investigation, who did you name as the person who provided the ladder to Mr. Stone?
Marley Miser, the defendant, admitted to owning the ladder.
In your professional opinion, why is this troubling?
This is troubling because in cases I have done where homeowners provide stuff, provide tools, and accidents happen, that they're responsible for it.
Objection, Your Honor. I object to the witness characterizing this case as troubling and characterizing the situation as troubling. I don't feel like they have the they don't feel like they have the ability to do that.
Counsel.
Anyone with a heart would say this case is troubling. Mr. Stone has suffered severe injuries and is no longer able to work the dream job he wanted to.
Overruled. Go ahead.
What should Mr. Miser have done instead given this situation?
Mr. Miser should have notified Remington about the ladder and the potential hazard it has.
Objection, Your Honor. This is speculation.
Counsel.
Alexis Anderson is an expert witness. He knows what should be done and to keep workers safe.
I'm going to allow the question. I'm qualified as an expert. Go ahead.
What should Mr. Miser have done instead given the situation?
He should have not provided the ladder and informed of any potential hazards.
Aside from the ladder, another important part of your investigation was the wiring that caused the burns sustained by Mr. Stone. Let us address that next. May I approach, Your Honor? I'd like to have this marked as plaintiff's proposed exhibit 3.
I have marked plaintiff's exhibit number 3.
Let the record reflect that I am showing opposing counsel plaintiff's proposed exhibit 3. Let the record reflect that I am showing witness plaintiff's proposed exhibit 3. How do you recognize this photograph?
This is the photograph I took in the Miser residence because it has my name on it and I was there on the investigation.
What is the subject of this photograph?
This is the 220-volt exposed electrical wire that Remington Stone fell on.
Is this photograph in the same condition as the day you took it?
Yes, it is.
Your Honor, I now move for the admission of plaintiff's proposed exhibit 3 into evidence.
Counsel.
Defense counsel has no objections at this time.
We'll have plaintiff's 3 now in evidence.
Your Honor, may I approach?
Go ahead.
What stood out to you about this wire you photographed at the defendant's home?
The wiring in this house was quite old, and this piece was worn so much that the wires were exposed.
What safety risk does an exposed wire present to anyone at a job site?
Anyone touching the wire could be seriously injured or even killed or electrocuted.
how was Mr. Stone shocked by these exposed wires if they were buried in the wall?
From witness
Objection, Your Honor. This is hearsay. Witness was not present at the job site.
Counsel?
The witness went to the job site and examined the area of the accident. That is how they got this photograph. They know that the wires were behind the wall.
Yes, but
I'm gonna sustain the objection. Go ahead and try to rephrase.
Your Honor, the council's got it.
All right, I guess that will end the examination.
may I
Thank you.
cross the witness? Thank you.
Go ahead.
Dr. Anderson, you testified that you were hired by plaintiff's counsel to testify today, correct?
That is true.
You would call yourself a high-ticket witness, yes?
Yes,
You have a PhD in industrial engineering,
that is true.
and you've written countless articles on various industrial safety issues, correct?
That is true.
Because of this, you charge a high fee, right?
Yes.
Objection, how is this relevant to this case and Dr. Anderson's investigation?
Counsel?
Your Honor, I'm trying to establish bias in the witness based on the fact that he's being paid quite a bit of money to testify today.
I'll allow some questions about the bias. Go ahead.
May I continue?
Yes.
This includes a $5,000 retainer, correct?
Yes.
And $700 an hour for preparation investigation.
Objection, how would the opposing counsel know fair rates of a lone expert witness in this field?
Your Honor, the witness testified in their affidavit to this.
I'm gonna allow questions regarding the compensation.
May I continue?
Go ahead.
And $1,000 for every hour you spend in court, correct?
Yes.
In fact, a typical fee in this case would be around $15,000, correct?
That is true.
So you must have testified at least partially for the money you're earning.
Well,
Objection, and the lawyer is being argumentative. They are trying to slander my witness.
I'm gonna sustain the objection on that one.
Thank you. Now, isn't it true that your grandfather was severely injured in an industrial meatpacking accident?
that is true.
And this changed the way that you view industrial accidents, right?
Yes.
So isn't it true that your personal experience with an industrial accident could have caused some bias in your testimony in court today?
It motivates me to.
Objection, and if anyone had their grandfather be injured in an accident, they would have their heart in making sure that these accidents don't happen again.
Exactly, Your Honor. I'm trying to establish bias in the way that the witness is testifying.
I'm going to sustain the objection. Strike the answer that began and then go forward.
Now, Dr. Anderson, you did a lot of investigation research in this case, correct?
That is true.
This included reconstructing the accident.
Yes.
Your Honor, may I approach and retrieve Plaintiff's Exhibit 2. Now, you state here, Dr. Anderson, that safety regulations were ignored, correct?
Yes.
Weren't these safety regulations ignored by Remington Stone?
Remington was provided with tools that ignored safety regulations.
Didn't Remington ignore the wet floor?
Well, he tried to get the job done.
But he ignored the wet floor.
Objection, and how would Alexis Anderson know this? They weren't there the day of the accident. They only know these from interviews.
Yes, but he did an interview with Remington, who's here today to testify. So I believe that if he's able to conclude anything about this accident, then he should be able to testify about what happened at the accident site.
Remington is here to testify, but Alexis Anderson was sequestered and did not hear Remington's testimony.
I'm going to sustain the objection. If you want to try to rephrase.
Yes, absolutely. Based on your interview with Remington, didn't Remington pitch the ladder against the wall?
Yes.
And this ladder was pitched above a clearly exposed electrical wire, correct?
Objection, and it wasn't clearly exposed. The wire was behind the wall.
Your Honor, counsel can't object to the content, this content. The witness is going to answer however they see fit.
I'm going to allow this question.
May you repeat the question?
Go ahead.
Now, isn't it true that this ladder was pitched above a clearly exposed electrical wire?
It was not clearly exposed. It was behind a drywall, which the ladder slipped on and caused the wire to become exposed and become a hazard.
Now, according to that report, you inspected the ladder, correct?
Yes.
Did you inspect any other part of the scene according to that report?
No.
Oh. And isn't it true that you didn't successfully reconstruct this accident?
Well, since the windows were open the night before and rainwater came in, it all was evaporated and I couldn't recreate the exact water that was on the ground.
Of course, yes, the floor wasn't wet when you got to the scene of the accident, right?
Yes.
So isn't it true that you never attempted to make the floor wet to continue this investigation?
No, because it would have been a hazard.
So you could have made more efforts in your investigation to get a better sense of the accident?
Objection. Alexis Anderson has repeatedly stated that they did not recreate the accident as it would be a hazard for anyone involved.
Yes, Your Honor, I'm just trying to establish that you did not successfully reconstruct this accident.
All right, I'm going to allow that question.
So you could have made more efforts in your investigation to get a better sense of the accident.
I suppose.
You also did interview some witnesses in court today for your investigations, correct?
That is true.
Isn't it true that you spoke mostly with plaintiff and plaintiff's counsel?
Objection. Remington Stone was the one who suffered the accident. Of course, they would interview plaintiff and those close to the plaintiff.
Yes, I'm just trying to establish bias because most of the interviews were conducted with plaintiff's counsel, Dakota Springs.
I'll allow it.
You spoke mostly with plaintiff and plaintiff's counsel in these interviews, correct?
I interviewed Remington Stone, Dakota Springs, and Marley Miser on your side.
Were you at the scene of the accident when it happened, Dr. Anderson?
No.
In fact, you didn't even know about the accident until over a week after it happened, correct?
Yes, because they hired me to investigate it.
So you don't know for sure what happened, do you?
From interviews, I have concluded.
But you don't know for sure what happened, did you?
No, I was not there.
So would you know for sure what angle the ladder was placed by Remington?
No.
Would you know for sure how wet the floor was?
Objection asked and answered.
Counsel?
I did not ask, I don't believe I've asked this question yet.
Yes, but the witness has answered that they did not know how wet the floor was because the water had evaporated.
I'm going to allow the question.
Would you know for sure how wet the floor was at the time?
No, nobody would.
Would you know for sure in what physical or mental state the plaintiff was at the time of the accident?
No.
So you wouldn't even know if your attempted reconstruction was even close to accurate.
I assume.
So you've just testified that most of your scientific conclusions are based on a minimal examination of the accident scene, interviews with most of the plaintiff's side, and speculation about the circumstances surrounding the accident.
Objection. This is a compound question.
Counsel, I want you to rephrase.
Absolutely. So you just testified that most of your scientific conclusions are based on a minimal examination of the accident scene,
Well, I am an expert.
but a minimal examination.
Well, I can conclude
Yes
information
or no,
from.
please?
Yes.
Interviews with most of the plaintiff's side.
3 on our side and 1 on your side. 2 on our side, 1 on your
Yes.
side.
And speculation about the circumstances surrounding the accident.
Yes, because I'm an expert and was hired
No
to do
further
so.
questions, Your Honor.
Thank you. Counsel, any redirect?
No redirect, Your Honor.
Thank you.
May I return the pieces of evidence to you?
Sure can. And the witness may step down. Thank you. Counsel, any further witnesses?
The plaintiff rests.
Okay, thank you. Counsel, you ready to proceed, or are you looking for a brief break?
Yes, the defense is ready to proceed.
We'd like to call Marley Miser to the stand, Your Honor.
Thank you. Please raise your right hand. You swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
You have a seat. State your name for the record.
My name is Marley Miser.
Counsel, your witness.
Thank you, Your Honor. Could you please state your address for the court?
I live at 2597 Lancaster Road, Depew, Nirvana.
And what do you do for a living, Mr. Miser?
I'm currently retired.
What did you do previously for work?
I was a home inspector for quite a long time, and before that, I was a construction worker.
How did you come to be involved with this case, Mr. Miser?
It's my house that Remington was working on when he was injured.
So directing your attention to the summer of 2021, can you tell me what, if anything, was being done to your house?
I was having the floors redone, windows installed, drywall removed, and I was having all of the wiring in my house redone.
So who did you contract for this renovation?
Acme Construction.
What role, if any, did you have on the job site?
I was never having any role. I sometimes offered advice to the workers, but I never had any role.
So what job, if any, did you have with Acme Construction?
I've never been employed by Acme Construction.
So when, if ever, were you employed by Acme to do this particular job under your home?
Never.
What, if any, supervisory role did you play in this construction job?
I had no supervisory role in this job.
Who was the supervisor of this construction?
Reese Withers was.
And how often were they on site?
Infrequently at best.
Directing your attention to September 23rd, the day that Remington was injured, who was supervising the job site?
Reese Withers was.
And where were you on this day?
I was there in the morning, of course, because it was my house, but after that I left to run errands.
So were you at the job site when Remington was injured?
No, I was not.
What did you observe that morning?
I saw Remington come into work. He was walking slowly, as if trying to maintain his
I
balance.
object, Your Honor. The witness is narrating.
Counsel,
He's just answering the question, Your Honor.
I'm going to allow.
May I re-ask the
Go
question?
ahead.
So what did you observe that morning?
I saw Remington come into work at about 7:30. He was walking slowly, as if trying to maintain his balance. His eyes were bloodshot, and he just looked very tired and out of it.
So what, if anything, did you say to him?
I asked him if he was all right.
Why did you do this?
I was concerned.
So what were you doing the night before his accident?
I went to a retirement party at the Painters Union Hall.
And can you describe for the court what you observed about Remington that night?
He was sitting at the bar.
I object, Your Honor, on the basis of speculation. I believe the witness is about to speculate about what he saw.
All right, counsel,
Your Honor, I'm just asking what he observed that night, that he was there, he saw it.
I'll allow answers to his observations.
Okay. Would you like me to repeat the question?
Yes, please.
Can you please describe for the court what you observed about Remington that night?
I observed Remington sitting at the bar, knocking back glass after glass of a dark liquid.
And what do you mean by that?
He was just sitting at the bar, and it was...
I object, Your Honor. How is this relevant to the injuries he sustained the day later?
Counsel,
Well, I'm trying to show, again, as I did in my cross of Remington Stone, the state that Remington was in when he entered work that morning. So I believe that this is relevant considering this would be what led to his state of...
I will allow the question.
Thank you. So what do you mean by that?
Well, he was sitting at the bar just drinking glass after glass of this stuff, and eventually he got up and stumbled and fell over, and he actually had to be caught by one of the people standing
I
next to him.
object, Your Honor. This question has been called for speculation, and the witness is speculating.
Counsel,
Your Honor, he's just telling us what he observed that night.
I heard an answer to an observation. I'm going to allow the answer.
Okay, I'll just move on. And what else did you observe about Remington?
I mean, when he got up to go to the bathroom, he stumbled and fell and was caught by one of the people next to him, and he would have fallen over otherwise.
And when, if ever, did Remington leave the bar?
Just that one time to go to the bathroom. He was at the bar drinking the rest of the night.
So that night, when he got up from that bar, he stumbled and he almost fell over, you said?
Yes.
I object, Your Honor. I do not believe these facts that the witness is talking about are even in the record at all.
Counsel, are they part of the record?
Your Honor, this is direct examination. It doesn't need to be in the record for me to ask the witness to testify.
Excuse me, is it in the fact pattern here?
In the fact pattern?
Yes.
I believe so.
All right. Is it in the fact patterns?
I do not believe it is. I believe this is made up. I've read the I've read the affidavits several times, and I do not believe recalling this. Maybe I'm wrong, but I do not believe that his stumbling to use the bathroom is in the affidavits anywhere.
It is in the affidavit, Your Honor.
All right, then I'm going to allow it.
Thank you. And how did you react to this?
My friend Fred was there, and I hollered across the party to him, I hope Remington isn't driving.
Again, these are not in the affidavits whatsoever. I mean, I've
This was
never-
in my signed and sworn affidavit.
All right, counsel, if somebody has that affidavit and can take
Your
a
Honor,
look.
I'll bring you the
We'll stop the
affidavit.
time at this point.
May I approach?
If you've got the area, you can recite it from there.
Just from there? Okay. Thank you, Your Honor. Right here. Without thinking, I shouted to Fred, who is near me, I hope Remington is not driving. Remington is so loaded that Remington is going to run somebody off the road. I understand that the party went well past midnight, and I bet Remington was there the whole
I
time.
object, Your Honor, on the basis of speculation.
Your Honor, this
Well, at
is,
this point, I'm just trying to determine with regard to what was in the script for the program, and if that was an answer that can be given based on it, because I think the witnesses are bound to their statements.
may I go back a little bit further in the
It
affidavit?
sounds to me as though you've got the answer, that the statement includes the answers that are being given. So with that, we are going to continue, put the clock back on, and continue with your questions.
Thank you, Your Honor. And when was this party?
This was the night before the accident,
And when did Remington arrive at work the next morning?
7:30.
And to your knowledge, when did Remington leave the party?
Much later than when I left, at probably midnight, 1 o'clock in the morning.
Your Honor, may I approach? Yeah, this marked for identification as Defense Exhibit B.
I have now marked Defense Exhibit B.
Thank you, Your Honor. Let the record reflect that I'm showing opposing counsel what's been marked as Defense Exhibit B. May I approach the witness?
Go ahead.
Do you recognize this document?
Yes, I do.
Can you identify this document?
This is the ladder that was at my house on the day that Remington was injured.
And is this ladder in the same state as that day?
Yes, it is.
Your Honor, I would like to make a motion to have this admitted into evidence as Defense Exhibit B.
Counsel,
I object. I would like to voir dire the witness.
go ahead.
How do you know that that is the ladder? It's just a picture.
Well, it is my ladder that I owned, and it is also in my driveway.
How would you know it's in black and white?
Because it's my driveway and my ladder, and I've had it for quite a long time, and I would recognize it.
I'm sure driveways could look the same throughout the country, correct?
Yes, they could.
But you're not, are you certain that's your ladder?
Yes, I'm 100%.
Oh, hold on.
I'm
This has been
100.
Hold on.
stipulated- This has been stipulated to be the ladder that was used in Remington's accident in the mock trial code of conduct.
Any further questions regarding that?
No, Your Honor.
All right, thank you.
Thank you, Your Honor. This is the ladder that Remington Stone used on the day of his accident, correct?
Yes.
And what do you notice about this ladder?
It has no rubberized footings on it.
No rubberized footings.
No.
So, with all of your years of construction experience, when, if ever, would you have used a ladder that so blatantly disregarded workplace
Object,
safety?
Your Honor. The witness is not put in as an expert on this field that the lawyer is talking about.
Counsel, what's your question again? Complete
I
question?
asked when, if ever, in all of his years of construction experience, he would have used a ladder that disregarded workplace safety. It doesn't call for an opinion, Your Honor.
I'm going to sustain the objection.
What was wrong with the room that Remington was working in when he was injured?
It had wet floors. And there was a.
I object on the basis of speculation.
Your Honor, this is his house. He would know what was at fault with the room that was in his own home.
Well, he can describe things about his home. He can't make the determination of what was at fault. So I'll allow the question as regards to his observations.
What were you contracting Acme Construction for in the room that Remington was injured?
In that room, the windows were being removed at the time of his accident, and I was having the drywall taken down. The wiring was supposed to be redone, and the floors were supposed to be changed.
What type of wiring was present in that room?
There was your typical house wiring for lights and such outlets, but there was also a dryer line.
When, if ever, did you tell the workers about this wiring?
I told Acme Construction when I contracted them that I wanted the wiring redone.
And why would you not tell the workers directly about this?
I was not their supervisor, so one, it's not my job, and two, I had already informed Acme that there was these wires that needed replaced.
And when, if ever, did you shut off the electricity to those wires?
I had been down at the breaker box and turned off the electricity prior to the construction job, but I had not been doing anything with them around the time of the accident.
No more questions at this time, Your Honor.
Thank you. Counsel.
You've worked in the construction industry for about 30 years, correct?
Correct.
It is correct to say that you've worked on all types of different structures, including houses, apartment buildings, and office buildings.
Objection, Your Honor. Relevancy?
I'm trying to build that he has a wide array of expertise in this field that this case is around.
I don't see how this would be relevant to the case, Your Honor.
Well, I'm going to allow a little bit of it here. Go ahead.
Thank you, Your Honor.
Did you get the answer into evidence, Your Honor?
I did not hear it.
All right. Is it correct to say that you have worked with all kinds of structures, apartments, office buildings, apartment buildings?
Correct.
So is it safe to say that you have a pretty extensive knowledge in the construction field?
Yes.
You had a number of issues with the structure that needed to be brought up to city and state code, correct?
Correct. That's why I contracted Acme Construction
Yes or no,
for it.
please?
Yes.
Your intention was to live in this home rather than sell it after this construction was completed, correct?
Not in the part that was being renovated.
Yes or no?
The half that was being renovated, I did not intend
Your
to live
Honor,
in.
could you direct the witness to a yes or no answer?
I'm not sure that question would have given a yes or no, but if you'd like to restate it.
Yes, Your Honor. Your intention was to live in this home rather than sell it after this construction was being completed, correct?
I was going to live in my half of the home, correct?
Yes or no?
Objection, Your Honor. Asked and answered.
I believe I heard some I heard some noises from the audience. I believe that's against the mock trial code.
Well, I didn't hear him, so at this point, I don't know what was said, but you're asking to have the witness admonished to give yes or no answers at this point?
Yes.
If you can answer the questions with yes or no, please do so. And if there's need for additional information, your attorneys can come back and ask.
Okay.
Your intention was to live in this home rather than sell it after this construction project was completed, correct?
Yes.
It is accurate to say that since you're not intending to sell this home for profit, you're acting modestly to protect this asset, correct?
Objection, Your Honor. Relevancy?
It would be in his interest to supervise the premises if he is planning to live in it so that his house looks better down after the construction is completed.
I still don't see how this question in particular would be relevant, Your Honor.
I'm going to sustain the objection if you want to go ahead and try to rephrase that question.
I will withdraw the question from the records. Is it true that the construction project on your home was largely the result of a financial opportunity provided to you by inheritance you received, correct?
Objection, Your Honor. Relevancy?
I believe that if he were to spend money on it and he has expertise in this field, that it would be under his interest to supervise the premises so the work gets done on time.
I still don't see how this particular question would be relevant, Your Honor.
I'm going to allow it. It's on cross.
Is it true that the construction project on your home was largely the result of a financial opportunity provided to you from an inheritance you received, correct?
Correct.
Would you say that this construction project to rehab your home is an investment into your retirement, correct?
Yes.
Would you say that watching over this project was an extension of protecting this investment into your home, correct?
Objection, Your Honor. Characterization?
I don't believe that's a objection in mock trial
I'm going
rules.
to overrule. Continue.
Would you say that watching over this project was an extension of protecting this investment into your home, correct?
I never supervised this project.
Yes or no?
I never supervised this project, so I can't answer the question accurately because I never
Yes-
watched
yes
over
or
the
no?
home.
I believe this question called for a yes or no answer, and he did not give one.
Counsel, the witness has indicated he can't give a yes or no to that.
Did you ever interact with the workers at your home when construction was being completed?
Yes,
When the work began at your residence, is it true that you were concerned that there wasn't enough workers?
yes, I was.
Is it also true that you were concerned about how slow the progress was in rehabbing your home?
Yes,
Given your concern about a shortage of workers and lack of progress, another worker was brought in to assist the project, correct?
yes,
That new worker was the defendant, Mr. Remington Stone, correct?
yes,
Is it true that you didn't approve much of Stone's work at your residence?
Objection, Your Honor, relevancy.
I believe that give me a second, Your Honor. I believe that since he was observing the other workers, that he's obliged to answer this question about Remington.
All right, I'll allow the question.
Is it true that you didn't approve much of Mr. Stone's work at your residence?
I thought it was kind of sloppy.
Did you routinely provide Mr. Stone with helpful advice to assist him with completing the tasks?
I offered advice, but I never assisted Remington.
Yes or no?
Yes,
Is it true that, despite not liking Mr. Stone, that you were willing to put up with him to ensure this project was completed on schedule?
Objection, Your Honor, compound question.
I believe this is just
I'm
one
gonna allow.
question. Is it true, despite not liking Mr. Stone, that you were willing to put up with him to ensure this project was completed on schedule?
yes,
Were you under the impression that Reese Withers trusted you with the workers at this project?
no. I never was entrusted with any of the workers. They worked for Reese and Acme, not for me.
Did Reese or any workers ever question the suggestions you provided during construction?
Yeah, a lot of the workers were unwilling to receive my advice.
Did you take on any tasks for Reese to help keep this house project on task?
I helped a little bit with the installation of vinyl floors, but that was it.
Was one of those tasks assisting? You asked Reese to watch over you were asked by Reese to watch over the workers, including Mr. Stone when he was absent from the job site, correct?
Watch them, not supervise them, correct?
During the morning of the accident, the new vinyl flooring that you spent good money on became wet from rain from the night before, correct?
I don't believe that was the new vinyl flooring that was installed. It had not been done yet. It was the old vinyl flooring.
Did you make any effort to put up something to keep water from getting into your home, to protect your flooring?
No, that's Acme's job.
It's pretty clear that the floors were slippery and wet. Did you make any effort to mop up the floor to protect it from being damaged or to not have anyone slip on it?
Again, that is Acme's
Yes
job.
or no?
No, I did not.
Is it true on the morning of Mr. Stone's accident, he asked you to use a 12-foot aluminum ladder located in your residence, true?
He asked me to use a ladder.
Yes.
Correct. He asked me to use a ladder.
Yes or no?
Yes, he asked me to use a ladder.
The particular ladder was in fact your property, correct?
Yes,
Additionally, that morning upon the accident occurring, it was discovered that there was exposed live wires where Mr. Stone fell, correct?
yes,
Were you certain that the electricity to this particular spot of your home was turned off after you learned about this?
I was pretty sure.
On the morning of this incident, did you ever communicate with anyone on whether or not you turned the circuit breaker off in that particular section of the home?
I did not because it is not my job. I had not been.
Yes or no?
No, I did not.
No further questions, Your Honor.
Okay, thank you. Any redirect?
Yes, Your Honor. What ladder did Remington Stone ask you to use on the day of his accident?
I didn't know at the time he asked. He simply asked me to use a ladder, never which one.
So, Why did you not inform the workers about the faulty wiring in the room that Remington was injured?
Because I had informed them that my house had wiring that was not up to code upon contracting the project, so I didn't see it pertinent to inform them of that daily. I assumed that since I had contracted Acme for it, Acme would take care of the wiring and I didn't have to worry about it.
And how long had the work been taking place before this accident occurred?
Quite some time. They had already been working on the house for a while, and this was not the first room they'd gone through and done.
And why is this significant?
Because they would have run into bad wiring in many other rooms before they ever got to this one. They should have easily known. I had contracted them for wiring, so there's not going to be good wiring in every part of the house.
Your Honor, I believe that the defense is only, I believe they're only supposed to ask about 3 questions. I believe they're over their limit.
No more questions at this time,
Thank you.
Your Honor.
Any redirect
Yes, Your
or
Honor.
recross?
You watched over the workers, correct?
I watched them.
Yes or no?
I watched them, correct.
No further questions, Your Honor.
Thank you. I believe that completes this witness.
Yes, Your Honor.
You may step down.
Yes, the defense would like to call Reese Withers to the stand next.
Okay, thank you.
Your Honor, there is still a piece of evidence on the witness stand. May I return it?
Oh, sure. Thank you. Please raise your right hand. Swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
Yes.
All right, please state your name for the record.
Reese Withers.
Counsel.
May I proceed? Good afternoon, good morning. Could you please state your name and address for the court?
Well, my name is Reese Withers, and I live at 625 West Johnson Street in Depew, Nirvana.
And what is your current occupation?
I work as a site supervisor for Acme Construction Company.
And how long have you held this position?
Since 2016.
And what positions, if any, have you held at Acme before this?
I've worked with Acme for 25 years, starting out as a construction worker.
Now, what are your responsibilities as a site supervisor?
I make sure that my crew has all the equipment that they need and that the job gets done safely.
Now, when did you first come to know the plaintiff?
I knew him, I came to know him when I started supervising him on August of 2021.
And what was Remington's responsibility when they began working for Acme?
They got the less desirable job of tearing down the drywall.
And why is this?
Well, all new workers get the least wanted job since we're unionized and work off of seniority.
And based on your observations of Remington's work, how did they respond to climbing ladders?
Well, they appeared to be bug-eyed,
Bug-eyed? What do you mean by that?
well, afraid, terrified almost.
Your Honor, this question calls for speculation.
Your Honor, I'm just asking the witness to testify based on his observations.
The first part of the answer was to an observation, and the rest began to be speculation about why they were doing that. So we'll strike that last part.
Absolutely. Thank you, Your Honor.
Thank you, Your Honor.
Now, what, if anything, do you do to make sure that your workers are safe when climbing ladders?
Well, I teach many safety rules, in this case being the 4-to-1 rule.
And what is the 4-to-1 rule, Mr. Withers?
Your Honor, I object. The witness is not an expert in the court today.
What's that?
The witness is not an expert, Your Honor.
Your Honor, I believe he can testify about the safety rules that he teaches to his workers.
I don't think it's calling for an expert. I think it's calling for a description of what he does. So I'll allow the question.
May I repeat the question?
Go ahead.
What is the 4-to-1 rule, Mr. Withers?
Well, it basically states that for every 4 feet that a ladder goes up, it must be 1 foot away from the wall that it is placed on.
And why do you teach this rule?
Because if they put the ladder too far away, there's a chance that it could slip out from under them.
Now, when, if ever, did you come into contact with the plaintiff outside of the workplace?
At the union retirement party,
And when was this?
September 22nd.
What was the plaintiff doing over the course of the evening?
They were sitting at the bar.
And what were they doing at the bar?
They appeared to be drinking.
And how late was Mr. Stone at the party?
Well, they were still there when I left at around 11.
Now, directing your attention to the morning of September 23rd, what were you doing?
I was supervising the window removal job.
And what happened then?
Some of my workers came and informed me that Remington had fallen off of a ladder.
And what did you do in response to this?
Well, I told my workers to go call 911 for him.
Now, when, if ever, did you speak to Remington?
Just before he left for the hospital.
And what did you learn?
Well, they told me their side of what happened, but I presume that they didn't properly place the ladder.
Now, what kind of ladder was the plaintiff on?
A 12-foot aluminum ladder.
Your Honor, may I approach and retrieve, I believe it's Defense Exhibit B, the ladder?
There you go.
May I approach the witness?
Go ahead.
Now, Mr. Withers, do you recognize this?
Yes, I do. It is the ladder that Remington fell on.
What do you notice about this ladder?
Well, it doesn't appear to have any rubberized footings. That's a huge safety hazard.
And whose ladder was this?
It's certainly not one of mine.
So it wasn't one of Acme Construction's?
Not in the slightest.
So it wouldn't be approved for company use on a work site?
No, it would not be.
Now, who, if anybody, was present on the work site during the accident?
I believe Marley Miser was.
And what was Marley Miser's responsibility as a homeowner?
Besides contracting us for the work, they didn't have one.
What company was in charge of the renovation?
Acme Construction Company.
What company are you an agent for?
Acme Construction Company.
Who is required to provide devices such as ladders for the proper protection of health and safety of workers?
Acme Construction Company.
And what company or entity is most involved with and concerned with employee safety?
Acme Construction Company.
Who is responsible for employee safety on the job?
Well, it starts with me. I have to teach all of my employees all the proper safety tools, but it then falls onto them to properly employ these rules.
And when training your employees, what do you make a point to emphasize?
Always safety. It's my #1 point that I always tell them.
No further questions, Your Honor.
Thank you. Any cross-examinations?
Yes, Your Honor. Before I begin, would you please direct the witness to strictly yes or no answers when they see fit?
Well, let's get your questions going first, and we'll see how the witnesses come,
Yes, Your Honor.
answers come about.
Yes, Your Honor. Is it true that Mr. Stone was not really impressive to you as a worker?
Yes, I do believe.
And you've previously described him as a slug, correct?
Sorry, could you repeat the question a little louder?
Have you previously referred to Remington as a slug?
I don't think I have.
Are you sure about that?
Yes,
Would looking at your affidavit help?
probably yes.
Your Honor, may I approach the witness? Could you please read right here? Out loud to the court, please.
Despite the fact that this slug Stone beat out my nephew for one of the remaining union positions at Construction Workers Local 1212, I gave Remington a fair chance because that's the kind of person that I am.
So, one more time. Have you ever described Remington as a slug?
Yes,
Thank you. Is it accurate to say that you personally felt that Remington was chosen to work on your job site over other candidates?
a small amount maybe.
Were you the appointed supervisor of the Miser construction project?
Yes,
Was the defendant, Mr. Miser, often present at the job site?
yes, they were.
Were you aware that the homeowner, Mr. Miser, had a past career in the construction business?
Heard it from some of my people around.
Okay. Did you recommend that your workers at the Miser project listen to some of the advice that Mr. Miser provided?
I do believe I have, yes.
Is it true that there were occasions where you were absent from the Miser construction project?
Yes, I was.
And did you rely on the Mr. Miser to keep an eye on construction progress while you were absent from the Miser residence?
Only to just watch workers.
Did you ever ask Mr. Miser to report anything to you concerning Mr. Stone specifically?
No, I don't think I did.
Were you present at the Miser residence the morning of Mr. Remington Stone's accident?
Yes, I was not in the same area as him, though.
Would you say that the ladder that Remington used, lacking the rubber feet, was a potential hazard?
Objection, Your Honor, this calls for speculation.
Counsel?
Your Honor, he's the site supervisor. He's discussed before that he's been through this, and it's a ladder. It's simple construction tools that are used in everyday use.
I'm going to allow the question.
Would you like me to repeat the question for you?
Yes, please.
Awesome. Would you say that the ladder that Remington used, lacking the rubber feet, was a potential hazard?
I would say yes, it was.
And did you or Acme Construction Company provide Remington with that ladder?
No, we did not.
Who did the defective ladder belong to?
Was Marley Misers, I believe.
Thank you. No further questions, Your Honor.
Thank you. Any redirect?
Yes, I have redirect. Mr. Withers, why were you off put by Remington as a worker?
Well, he just appeared to be an accident waiting to happen.
Now, why would you recommend to workers that they would listen to Marley Miser?
Well, I assumed that they had at least some sense of what they were talking about. However, I'd prefer if they came to me over them.
Of course. And when, if ever, did you instruct Remington to use such a dangerous ladder, or anyone at Acme Construction?
I never did.
No further questions, Your Honor.
Thank you. Any recross?
Yes, Your Honor. You were absent from the job site quite often, correct?
Objection, Your Honor. This is not in the scope of my redirect.
Counsel, the recross would be based on what was asked in the redirect.
Yes, Your Honor. No further questions.
Okay, thank you.
Thank you.
At this time, the witness may step down. Counsel, any further witnesses?
Yes, Your Honor. The defense would like to call Dr. Skylar Harris to the stand.
Please raise your right hand. You swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
I do.
All right, please have a seat and state your name for the record.
My name is Dr. Skylar Harris.
May I begin? Dr. Harris, can you tell the court, can you state the address for the court?
Yes, my address is 2050 LeBurn Street in Gotham, Nevada.
And how old are you?
I'm 60 years old.
And what do you do for a living?
I'm a professor in industrial arts in the University of Nirvana.
And what else do you do for this department?
I am also the assistant dean.
What, if any, degrees do you hold, and from where?
I hold a bachelor's degree in mechanical engineering from SUNY Albany. I also hold a master's degree in mechanical engineering technology from Niagara University. And I also hold a PhD in fluid dynamics from New York University.
What, if any, courses have you taught?
I've taught several courses, such as building codes and construction practices, accident reconstruction, and structural systems.
And how long have you been teaching these courses?
Oh, for around 30 years now.
What, if any, articles or textbooks have you published?
I've published about a dozen peer-reviewed articles and co-authored a textbook.
And can you give me the name of this textbook?
It's Accident Reconstruction, Theory and Practice, 3rd edition,
And when was this textbook published?
in 2018.
Dr. Skylar Harris, have you testified in court before?
Yes, I have.
Your Honor, I would ask to have Dr. Skylar Harris be deemed as an expert witness in the field of accident reconstruction.
Counsel,
Your Honor, I would like to voir dire the witness.
please proceed.
What was your job when you were first hired by the University of Nirvana?
Well, I first just started off as an assistant along with several different departments. I was kind of moved around.
When were you hired as an assistant professor?
It was 30 years ago, like I had said.
No further questions, Your Honor. There is no objection to Skylar Harris being an expert witness.
Thank you. Please proceed.
Thank you. When did you first become aware of this case?
I first became aware of this case in September of 2021 when Acme contacted me.
And after they contacted you to help out, what, if anything, did you do?
I first got a medical report of Remington Stone, as well as visited the accident site and spoke to a few witnesses.
Once you got on site, what, if anything, did you do?
I took a few measurements, looked at the ladder and the very old vinyl flooring, and I went through what could have happened during the accident.
In your expert opinion, Dr. Skylar Harris, when should a properly pitched ladder slide away?
Oh, a properly pitched ladder should never slide away.
Now moving on to dynamic movement, when should it become unstable?
It should only become unstable if it was not properly pitched and angled.
And why is that?
That is because the vibrations and movement would break the friction between the anchor of and the floor, so it would slip away.
Ideally, what angle should a ladder be placed at?
75 degrees or more.
And what rule is this commonly known as?
It's commonly known as the 4-to-1 rule.
Can you explain to the court what the 4-to-1 rule means?
Yes, I can. That means that the base of the ladder should be 1/4 X away from the wall, and since the ladder in question represents X, and it's 12 feet tall, it should be no more than 3 feet away from the wall.
Moving on to the flooring, can you describe this vinyl flooring?
It's very old and porous.
And what did your testing indicate in regard to the flooring and this position ladder?
My testing indicated that the aluminum edges of a properly pitched ladder with approximately 180 pounds or more would have slightly indented the vinyl flooring, providing a stable base for the ladder.
Your Honor, may I achieve Plaintiff 1? Dr. Skylar Harris, can you look under the vinyl section and look where it says weight? Can you tell the court the approximate weight of Remington Stone?
He was about 180 pounds.
So based on your testing above and the weight of Remington Stone on this medical report, should have there been a stable base?
Yes, there should have been.
Your Honor, may I approach? I would like to have this document marked for identification as Defense C.
We now have marked for identification Defense C.
Let the record reflect I am showing opposing counsel what has been marked for identification as Defense C. May I approach the witness?
Go ahead.
Dr. Skylar Harris, do you recognize this report?
Yes, I do.
Objection. This document is not in evidence. It is only in proposed evidence, so the witness cannot read out the contents of it.
I wasn't
All right.
going to ask her to read out.
I think the question was, do you identify it? So I'll allow that question.
Yes, I do identify this document.
Can you tell the court what date is written on this document?
October
Objection.
25th.
Now they are reading out the contents of it with the date, and it is not yet in evidence.
I'm going to sustain that objection.
Dr. Skylar Harris, is that your signature?
Objection. They are once again reading out the contents of the document without it being in evidence.
Your Honor,
I'm
I'm just trying
I'm going to allow that question. Go ahead.
Could you repeat the question? I'm sorry.
Is that your signature?
Yes, it is.
Your Honor, I would like to have this accident report moved into evidence.
All right, counsel.
No objections.
All right. Defense C is now in evidence.
Dr. Skylar Harris, can you read to the court out loud the last sentence on the first page and on the word slightest?
Yes, I can. I positioned the ladder on the wet portion of the floor using the 4-to-1 rule and asked a worker who is approximately the same height and weight as Stone to climb up the ladder. The medical report shows that Stone was 73 inches tall and weighed about 180 pounds. After directing the worker to make the motion purportedly made by Stone, striking the wall with a claw hammer, I observed that the ladder did not move in the slightest.
Dr. Skylar Harris, can you tell us the date of this report?
Yes, it was published October 25th, 2021.
So based on your report, even if the floor was a little wet, should have Mr. Stone fell?
No, he should not have.
Based on your investigation and your expertise, what can you conclude about this?
Based off my expertise, I'd say that if the ladder that Remington Stone placed was not properly pitched.
Okay, no further questions, Your Honor.
Thank you. Any cross?
Yes, I would like to cross the witness.
Please proceed.
You are a professor in the University of Nirvana, correct?
That is correct?
You teach multiple courses related to construction, correct?
Correct.
You've also published more than a dozen articles and even co-authored a textbook, correct?
Peer-reviewed articles, yes.
Yeah. According to your accident report, you conclude that Remington Stone's injuries were sustained from a fall at the Miser residence, correct?
That is correct.
In that report, you suggested that Remington may have failed to position the ladder to the 4-to-1 rule, correct?
Very correct, yes.
In your expert opinion, would you say that Remington, who has experience in construction, should have received training on this 4-to-1 rule when using a ladder, correct?
By Acme, yes.
Wouldn't that experience suggest that Remington probably would have followed the 4-to-1 rule anyway?
Sorry, could you please repeat that?
Wouldn't that experience suggest that Remington probably would have followed?
Objection, speculation?
They are an
I
expert.
haven't heard the whole question. Go ahead with the question again.
Wouldn't that experience suggest that Remington probably would have followed the 4-to-1 rule anyway?
Objection, speculation.
The witness is an expert witness. They should know what workers should do when given proper experience and teaching.
Counsel, you've qualified this as an expert. I'm going to allow for the hypothetical.
Could this accident happen even if the 4-to-1 rule was perfectly executed by the most competent, most experienced, and most steady worker?
Would it have happened?
Yeah.
The accident would not have happened if it was properly pitched.
This accident took place in a 125-year-old Victorian house, correct?
Correct.
Is it true that in older homes, like the defendant's, often contain obsolete and potentially hazardous building materials?
Possibly.
Is it true that a common hazard in old houses is unsafe wiring?
It's common in some places, not in others. Depends on where you are.
Yes or no?
I can't give a straight answer to that.
In your professional opinion, would it be reasonable to expect the homeowner to disclose potential hazards in the workplace, like exposed old wiring?
Yes, it's the company's job to do that.
How would the company know if the homeowner didn't tell them?
Well, they are supposed to have the proper communications with the homeowner to be able to discuss work safety and the environment that the workers are going to be placed in.
So it's the homeowner's responsibility to disclose
No, it is
hazardous-
the company's responsibility to talk with the homeowner. The homeowner's only responsibility is to assign what company that they're going to be working with.
But if the homeowner didn't tell the company that there was hazardous material, the company wouldn't know.
He did tell the company, just he forgot to shut off the wires. That was literally the only thing that happened.
Thank you. Was unsafe and exposed wiring a contributing factor to the injuries sustained by Mr. Stone?
Yeah, to
You
an
were not,
extent.
you were not a witness to Mr. Stone's accident, correct?
Correct.
It would also be accurate to say that you did not investigate the accident until a few weeks after it had occurred?
Yes, that is correct.
Would it be plausible that in a construction site, repairs and work may have been completed in the few weeks between my client's accident and your visit to the scene?
I'd say not, since it was an accident that happened and it was being investigated at that time as well, so.
Yes, but in between the time of the accident and your investigation, could work have happened?
I'd say no.
They still wanted to keep on schedule.
But they didn't mess with that specific area. They continued work in the other places.
In your accident report, you say that you recreated the accident, correct?
Yep,
Did you attempt to simulate the wet floor conditions of the day of the accident?
I did. I placed 2 quarts of water, which would have been enough.
Is it possible that in your recreation of the accident, you may not have had the precise amount of moisture to accurately recreate Mr. Stone's accident?
It would not have mattered how much water was placed as long as there was water placed on the vinyl flooring. You can't flood the whole room, and you can't put no water on it because there was water involved. However, 2 quarts was definitely enough to go through how the accident could have happened.
You weren't present at the time of the accident.
No, but it's common knowledge with how much rain could be poured into the room through only a window.
Out of speculation.
Out of my
Objection,
expertise.
What's the question in that?
The witness is speculating how much water fell and is unable to give a precise amount to what actually happened. It could be more, it could be less than 2 quarts of water.
Counsel?
I didn't hear a question when he just said speculation.
I'm going to, I'm going to strike that portion. If you want to rephrase, go on. I'm going to.
Thank you.
Is it possible for it to have rained more or less than 2 quarts of water?
It's possible, but it wouldn't have affected my investigation.
Your Honor, could you please direct the witness to answer in yes or no questions?
If their answers are capable of being answered yes or no on cross, if you could do so.
Yes, Your Honor.
It would be difficult to know the exact amount of water that was on the floor that morning, correct?
Correct.
Your report also mentions that you asked a worker at the scene to recreate this accident, correct?
That is correct.
Given the possible danger of a slip and fall or electrocution, isn't this type of reenactment unethical?
No.
So it is perfectly ethical to endanger a worker.
I made sure my investigation was safe. It is my job to do that.
Given the obvious thought that you did not want to harm this worker, you may have had to include other variables that were different from the actual accident during your reenactment, correct?
Nope.
So you put a person in a dangerous situation willingly, without taking any precautions to ensure their safety.
Objection, this is a compound question.
If you can break your question down into.
So you put a worker in a dangerous situation, correct?
No, I made sure safety measures were taken, but I still followed what exactly happened during the accident.
The accident led to severe injuries, correct?
That is correct.
So if you followed what exactly happened with the accident, then the worker would have sustained severe injuries.
I followed what could have happened, and so I had the worker go up on the ladder, but it was properly positioned due to the 4-to-1 rule and the angling that I am very well aware of would not have led to the ladder slipping.
So you're saying that you recreated how the accident could have prevented and not how the accident happened.
I went through both. That's what an investigation is.
Another factor in your reenactment was that the subject you recruited was the approximate height and weight of Mr. Stone, correct?
That is correct.
In your accident report, you list that the plaintiff's height was 73 inches, correct?
Yes,
That would be 6'1", correct?
that is correct.
Could you please read the height of the plaintiff on that medical report?
The height?
Yes.
5'10". It says 5'10".
In your report, you list that the plaintiff's weight was about 180 pounds, correct?
Correct.
And that 180 pounds would be required to provide a stable base for the ladder.
Approximately 180 pounds or more, yes.
Could you please state the weight of the plaintiff that is on that medical report?
He is approximately 180 pounds.
Could you please state the exact weight?
177 pounds, 3 pounds off from 180.
Yeah. In your expert opinion, could having variables such as not having the precise height and weight of Mr. Stone cause your experiment to provide an alternative conclusion?
No, my investigation was very accurate, and I went through all the steps, what could have happened, and no matter the weight, it could affect a little bit with how it indented the flooring, but if it was properly positioned, it wouldn't have fallen anyway.
Was using a subject with the approximate height and weight a convenience that you used during your investigation? Yes or no?
A convenience? Sorry, can you reword the question?
I can
All right, time is run, counsel.
If I may, could I redirect my witness?
Go ahead.
How did unsafe wiring play a part into this case?
It was not marked or anything, and it just, because of the floor being wet and he falling off of the not properly positioned ladder, caused harm in the accident.
Did you turn the wire off during your investigations?
No, I did not. I did, but it was not like that in the accident.
Objection. The witness has given 2 answers to the question.
I apologize.
Counsel? I'm going to have to say that I will have to take that into consideration. I'd be more concerned if we had a jury, but I'll deal with the answer that was given, or the answers that were given.
Thank you, Your Honor.
No further questions.
Any further cross?
There is a recross.
Go ahead.
Yes or no? You state that the water was a factor in the plaintiff's fall.
Objection, this is not in my redirect.
The witness answered that the water was a factor in your redirect.
I'm going to allow the question.
Could you repeat the question, please?
Yes or no? Did you state that the water was a factor in the plaintiff's slip and fall?
No. If you'd let me explain, I could tell you why.
So, did you lie under testimony? Because you did state in your redirect that water and the improper placement was the cause of the fall.
I never said that it was the cause of the fall. I said it played a role in how he was harmed. It wasn't the cause of the accident. He didn't properly pitch the ladder. That was the cause of the accident.
So water played a role in the accident.
Not in the role in the accident, the role in his harm.
The harm was the result.
Objection, this is over the 3 questions.
All right. 3 questions are asked and answered. You may sit down. That would conclude this witness. So you may step down.
Thank you, Your Honor.
Your Honor, there is evidence left on the witness stand. May I return it?
Sure. Thank you. All right. This one, I believe the plaintiff can have back. It's not in evidence. That one there. If you could hand that to plaintiff, please. Stand back to them. Evidence. Counsel, would you like a few moments to prepare for closings? Are we ready to proceed?
Your Honor, we request a 5-minute recess.
All right, we will take a break here. Give yourself about 5 minutes to prepare your closings.
May I retrieve the evidence?
Yes. You want plaintiffs, defendants. All rise.
All rise. The Honorable Michael J. Sullivan presiding.
Have a seat. All right, counsel, have you had enough time to prepare, and are you ready to make your closings?
Yes, Your Honor.
All right, let's proceed then.
Thank you, Your Honor. May it please the court, Your Honor, fellow counsel. In court today, we have called into question who we should blame for Remington's injuries. Does the responsibility fall on Mr. Miser, Acme Construction, Remington himself, Reese Withers? The list goes on. Today, my team and I have shown through witness testimony coupled with the stipulated evidence of this trial that the man in court today, Marley Miser, has no means to be blamed for Mr. Stone's injuries. Miser's testimony itself proved that not only did Remington choose to use a ladder, an obviously unsafe, defective ladder, but also that this ladder was not meant for workplace use at all. Remington went out of his way to choose this ladder right here, one that was obviously unsafe without rubberized footings. And so Miser did not keep an unsafe workplace. Furthermore, Miser was not a supervisor on this job site, as counsel would like you to believe. He was solely a layman, the homeowner who contracted the work. Miser may have helped the workers and helped move the job along, that we all may agree on, but he was never employed by Acme, nor was he ever Remington's boss, nor did he ever exercise direct supervisory control. Counsel proved that Miser watched the work, but never that he actually acted as a supervisor. This dismisses him of all liability shown through the precedential case of Songus v. Apex Construction, in which the homeowner was dismissed of liability because they had no supervisory control. This directly parallels Miser's situation. I would also like to remind you of two labor laws relevant to this case, Labor Laws 240 and 241. In both of these cases, it is explicitly stated that liability of an accident is denied to owners of one or two family dwellings who contract for but do not direct or control the work, homeowners such as Marley Miser. Further abdicating liability from Miser was the testimony of Reese Withers. Through his testimony, we have proved that the plaintiff was not in a proper position to come to work on the day of their accident, staying out extremely late at a retirement party the night prior. It was further established that on that fateful day of his accident, Remington chose to use a ladder that was not even intended for Acme Construction use. It was even stashed away from where workers were intended to be stationed, relieving Miser of any liability that could be argued from Labor Law 200. It was also shown that there was repeated instruction in workplace safety, which further proves that this job site was focused on the safety of its workers. Elaborating on this position specifically was the testimony of Skylar Harris. She reconstructed the accident scientifically, something that could not be said of the plaintiff's expert witness. Through her testimony, through her reconstruction, it was shown that Remington would not have fallen if they used the 4-to-1 rule. This report shows the sole cause of the accident is Stone's failure to properly position the ladder from the wall. Stone's improper positioning of the ladder resulted in the injuries Stone suffered. This report shows conclusively that it was not the workplace or Marley Miser that caused the ladder to fall, only Remington's failure to follow workplace safety protocols. Her cross-examination proved nothing, only showing speculation by counsel that Remington would not have broken regulation because of his extensive training. But this only supports our argument. As shown through Harris's investigation, he had to have disregarded these trainings which had been proven to take place. It was solely Remington's actions that caused this accident. Even through the plaintiff's testimony, we can see that Miser should not have been held liable. Remington himself admitted that Miser did not tell them to use the ladder. He further admitted that he purely chose the ladder based on the assumption that it followed safety protocols. He did not review the ladder nor check its safety. From Alexis Anderson, we see nothing but speculation. They said it themselves, their reconstruction of the accident was faulty. The ladder nor the wet floor caused the accident. They further speculate about Miser's involvement, establishing no link between Miser and the accident. They furthermore are a biased witness, having personal relations with Skylar Harris and getting paid very heavily to testify at this trial today. Another biased witness would be Dakota Springs, who's personal friends with the Stones and is even the guide parent of Mr. Remington Stone. Their testimony is riddled with holes. They left the company party Remington attended prior to their injury before Remington, leaving time where they can't testify to what Remington drank or what Remington did. Furthermore, Dakota Springs testified that Remington may have relapsed into their alcoholism. This is elaborated on by the medical report of Remington Stone. And I quote, Patient presented disoriented, lacked balance, and hand-eye coordination, consistent with shock and or being under the influence, Your Honor. While we hate to suggest this, it is within a reasonable claim that the plaintiff was unable to go to work that day, likely because of the party that they attended the night prior and what they drank at that party. Your Honor, what we see here is nothing more than a simple story. Remington arrived at work in a sorry state of mind and body. On an old house, workers may find faulty wiring and other problems, but Remington was not injured because of this. They were injured because of a lack of care and the choices that they personally made. He was not forced to go to work by anybody but himself, and when he got to the work site, he chose an unsafe ladder that was stashed away. He pitched that ladder on slippery ground. He pitched that ladder in an unsafe manner. He made the choices that led to his injury, not Marley Miser. There is no liability that falls on Miser, no matter what legal statutes the plaintiff tried to defend with, or whatever speculative evidence they try to argue with. Thank you, Your Honor.
Thank you. Counsel?
The plaintiff would like to proceed with their closing statement.
Go ahead.
Your Honor, today we have provided the burden of proof that finds the defendant, Marley Miser, liable for the horrific injuries sustained by our client, Remington Stone. At the time of the incident, Mr. Stone had overcome personal obstacles to reclaim his career. He shared with us his celebrated sorority and discussed his dedication to his new job, capping his incredible recovery. Like any normal worker, he had a few expectations for his workplace. Give him a task, protect his well-being, and give him a paycheck for a hard day's work. Unfortunately, his accident has cost him all of this. Remington Stone was fortunate enough to be present and testify about the day of his accident, providing us with his take on the incident. He discussed the defective ladder owned by the defendant. More importantly, he acknowledged that Mr. Miser served as a frequent participant at the workplace day to day. This clearly created a workplace relationship, giving Mr. Stone and the other workers at the construction site the impression that Mr. Miser was to be respected. He was to be listened to. He was not to be disagreed with. Otherwise, it might cost someone their job. This pressure was intensified by the fact that Mr. Miser clearly made himself present to ensure that his project remained on schedule. Dakota Springs, a reputable member of the Local 1212 Construction Workers Union, testified Remington's good character. She helped discuss Remington's qualifications for the job he was hired to do and provided extensive context on his honest, hard-working personality. Dakota knows Remington better than anyone who spoke today. She, like many upstanding people, recognizes that people can struggle in life. Dakota's reference clearly demonstrates how our client has succeeded in his recovery and was on the upswing until the fateful day of his accident. Dr. Alexis Anderson, an expert in the field of accident reconstruction, provided a summary of his findings. This provided a logical pattern of facts with evidence making a sound conclusion. Marley Miser contributed to the hazardous conditions that caused Mr. Stone's accident. Dr. Anderson laid out that the defective ladder belonging to the defendant, coupled with a wet floor that went unattended, caused the plaintiff to fall. More importantly, the defendant clearly did not make the construction crew aware of all the potential electrical hazards of the home. Mr. Miser, in his own sworn affidavit, even mentioned how he couldn't remember if he turned the power off, and he tried to pass blame on others. My client sustained horrific burns that happened as a result of this clear miscommunication. The defense has made an ill attempt to protect Mr. Miser, who has readily admitted he failed to notify workers in his home about the faulty wiring. In fact, Mr. Miser even tries to pass blame to Remington and his co-workers for meddling with it. This explanation is faulty and matches yet another faulty claim about the ladder Remington fell from. Mr. Miser claims the ladder was garbage and ready to be taken away. Yet, when Remington inquired about using the ladder, Mr. Miser failed to prevent him from using it. The defense also failed to establish who definitely had supervision over the job site. Yes, a contract had the Acme Construction Company listed as the party in charge of the work site. Yes, Reese Withers was appointed to be the supervisor of the Miser project. However, his frequent absence led the defendant to being the de facto supervisor or agent in charge. Mr. Miser's presence every single day had an impact on that job site. The contribution of his opinion had an impact on that job site every single day. Mr. Miser reporting progress about these workers on a regular basis makes him an agent associated with this project. Reese, with the added benefit of further extinguished that the latter is not Acme's responsibility, but rather that of Marley Miser. In accordance with the law, this qualification will not exempt him from liability in this case. Skylar Harris also refused to give clear answers. Here's shown when she gave two different answers to the same question and denied that water played a role despite previously saying that it did. Labor Law Section 200, 240, and 241 states that parties are responsible for providing reasonable workplace safety equipment in operation. Furthermore, those responsibilities include contractors and their agents. The facts of this case and the law as written is on our side. Our case has a precedent. As we mentioned in the beginning, the case Tsongas versus Apex Construction has identical circumstances. In that case, it was argued that Labor Law Section 200 was violated because a homeowner exercised supervisory control of construction and had known of a danger present at the job site. Mr. Miser is the owner of this house. He exercised supervision as the agent in charge and was aware of the unsafe ladder and wet floor conditions that led to Remington's fall. Furthermore, Mr. Miser was aware of an electrical danger to all of the workers at this job site and failed to provide notice to anyone. In the ruling handed down from Tsongas versus Apex Construction, the court ruled that the homeowner failed to establish prima facie that they lacked notice of the dangerous condition that brought about the plaintiff's injuries. Once again, proving that Marley Miser had indeed contributed immensely, if not entirely, to fault brings each and every one of us here today. Our argument has satisfied the burden of proof. Mr. Miser is reasonably responsible for Mr. Stone's injuries due to his negligence. This sleeping dog has awoken from his own slumbers. We ask the court for a ruling that provides reimbursement for our client's legal costs to file an appropriate workplace suit against homeowner Marley Miser. More importantly, we ask that the court require the defendant to provide Remington Stone's pain and suffering that resulted from Mr. Miser's negligence. Thank you, Your Honor.
Thank you. All right. I'm going to take a brief recess. We'll be back on the record in a few minutes.
All rise.
Have a seat. The matter before me, it is hard not to want to give the plaintiff a large verdict for the injuries suffered. However, and again, I don't know why the fact pattern would be set up in a way that leaves you without having recourse against the contractors who certainly would have borne the responsibility. But in this case, it does appear that the power didn't get turned off, and as a result, injuries were sustained. So we will find in favor of the plaintiff for the damages being sought. With that said, now we get down to the important part for all of you. In this case, the points, as I've totaled them up, go in the favor of the defense in this case. It was, I've done several now of the finals, and before that I coached a team for a while back early on when the program started in our county. Today was probably the only time that I've ever given perfect scores for the openings and the closings, because I really thought the use of the statutes from both teams, the case law, and then in the closings, referring back to what we said in the beginning about the case and being able to make that connection. I mean, that was good, because it's hard, because you don't know what you're actually going to get in while you're doing this. You don't know what's going to be done. But to know that your opening and your closing's tied together, and for both teams, that was good. Going forward, there are a few things, though, to be prepared for. Unfortunately, I don't know if you guys are all seniors or if you're going to be back again for another year, so hopefully you will. Hopefully you will, because your juniors are younger and not because you're seniors and you're going to come back by any other reason. And from your work today, I doubt that would be a problem. But I'll share some things, so hopefully some of you are participating in the future. Try not to refer to the evidence that's been marked as proposed. Simply call it marked for identification. I have in front of me Plaintiff's Exhibit 4, marked for identification. Proposed just isn't going to be the language that a judge at the next level is going to want to be hearing. Also, with regard to evidence, I believe the picture of the ladder never actually got marked into evidence. I don't believe it was handed back to me to put the evidence mark on it. No. With that, always the exhibits, and some of you, if you've been at this final before, the evidence are your possessions, if it's the one you're bringing in, so you want to make sure you get it marked. You want to get it over to the witness. There's no reason to bring it back to the judge while you're asking the witness questions. If it's already been marked into evidence, or they're being asked questions about it to get it into evidence, keep it over there with them. A couple things: in a timed event, it saves you the few seconds that it took to walk it over to me and then walk it back over. So let the witness have it. Make sure once they're done and it's been marked into evidence, you bring it back. Generally, there's a table somewhere in a courtroom that you would put the evidence on. In this case, and if you have a similar setting at the next trial, make sure you bring it back to the bench so that it's in front of the judge once it's in evidence. I did have a couple of things left up with me that weren't moved into evidence. And the other side, if you're seeing that, you may want to make sure that you point it out and you get it off the judge's bench, because the last thing you want is the judge, while listening to questions and maybe a little multitasking, taking a look at that document that may not be in evidence, and you left it in front of them. And human nature, if I've got something in front of me, I may want to take a look at it. One comment on the closing, twice it was referred to, I think, as stashed, that the letter had been stashed. I don't remember getting the witness to say anything about that. So when you've got your openings and your closings, sort of use that as your checklist. Again, you're not going to get everything in. There's not going to be enough time on something like this. But when you know what your closing is going to be, and you're going to stress that, and it was stressed twice, I heard it, mentioned, stashed. Make sure you get the witness to say that, or you get enough testimony that you can make that jump. That just stuck out a little bit to me, that I don't remember hearing the much detail about the ladder being out of sight, or him stumbling on it somehow. So it was a little bit of a loose connection there. And again, maybe you did, but you also have to remember sometimes the person listening isn't catching every fact either. So just make sure that, take your closing almost as a checklist, and even if you're not going to prove your case in a 5-minute direct, but if you at least make sure that the things you want to mention and you plan on mentioning in your closing, because you've pre-written that you've got those things in that you're highlighting. Keeps it together that way. Don't back off on objecting when you get rulings against your objections. You're not going to win all of them. Generally, you're not going to piss somebody off as a judge because you're asking, you're objecting over and over again. Sometimes, if the judge feels you've gone a little too far with the same objection, listen to some of the answers that they're giving you. It's sort of an indication, let it go a little bit, don't keep objecting to that. And then be careful, because sometimes you have a really good objection, and I know you guys were jumping quick before the whole questions were out. And I think there was a tendency then to maybe get a little bit nervous about raising objection again. The objection would have been good had the whole question been in, okay? So timing of it, you gotta be careful of. And sometimes you gotta come back. It's not a matter of worrying about getting the judge mad because you're objecting. So just because you've been overruled a few times, don't panic. It's hard sitting here, especially in these, because there was a couple of times where I wanted to look up, like, now? And it's the same thing, you really don't do it in the real courtroom either, but you sit there and you wonder, why are they not objecting to that now? I mean, they knew what they wanted to do. So watch your timing of it. Make sure you get the whole question in. And sometimes, somebody objected to a question, and particularly in a case like this, where you're doing it, you kind of know what the answer is going to be. And if there's a chance that the answer isn't going to hurt you, you may want to decide, well, I'm not going to object on that one, because I know when they answer it, it's not going to hurt. And that happened a couple of times where the witnesses' answers then played out pretty well. I do commend all the witnesses. They really seem to know their stuff. I will, also be cautious to make sure you follow the tournament rules, especially at the next stage. If there's something out there that wasn't in the packet, and the quicker you can acknowledge that it wasn't or that it was and put it aside, the better off you'll be. But those are the kind of things, especially like in this, when the competition is so close, those little kind of things can make a big difference. So be careful on that. Just, again, focus on it, on each of the attorneys getting a chance to prove one or two of the elements, getting an exhibit in, getting a witness certified as an expert, getting, because you've only got 5 minutes, so make sure you get in one of those skills. I always feel bad for the attorney who asks their questions and the other side never objects, because you haven't had a chance to prove the skills that you want to be able to show. I knew how to get around that. I know some people think, great, I got through the whole thing without an objection, but it didn't help get the points because you didn't have a chance to demonstrate any skills other than going through your questions. But again, it was a pleasure to have the opportunity to be with you today and to listen to the efforts and the work you put into this. I did coach a team a long time ago, so I know how much effort it is. And I also know at this time of the year, you guys have a number of other things going on in your lives. So I'm glad we're able to do this Saturday to get you out of here in time to go do those other things you have to do for high school students. So congratulations for your effort, and I want to commend all of you for the time and the performance that you put on today. It was a very enjoyable opportunity for me. Thank you.
Thank you.